Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today we have an update on the Ripple v SEC lawsuit. A lot of things came out over the last 24 hours, and the strange part is we kind of missed it when it first came out. And that's because the source, who we usually use to give us the updates instantly, well, he is gone for a little while. So to me, it's also a little bit of extra work now to find exactly when these things come out and what exactly they mean. But we'll get to it. It's about to be really freaking interesting, and I think you guys will enjoy. Having said that, guys, if you are enjoying these daily crypto updates, make sure that you press that like button. The first time a video goes to 2,222 likes, we're giving away $250 worth of crypto. And guys, check out the Bybit competition. A link is going to be down below. All right, let's check it out. So Crypto Law just posted over on their Twitter that something went on, right? And that's where I was like, oh, wait a minute. James Fillon, who we usually use, he's gone and he said so. So I have to check if there's a lawsuit update, and when I checked it out, there's been 3 things which just got posted. So let's quickly check out the Crypto Law, Twitter profile, and we can actually check out the website too to see everything which has happened because, well, there's multiple different parts. So this is 383, which is the most recent document, but let's quickly check first if we can actually see some prior documents too, because he might have even not posted them, guys. It's possible, but I hope so. So, okay, let's quickly check it out. 16 hours ago, we got one, and maybe that's it. Maybe it's just 2 in 1, kind of. I'm going to say let's check it out, and we'll get to it. So here is from 16 hours ago. This is a number 381. Okay, so all we need then is 382. But I'm not exactly sure where that's supposed to be, because that is the one that you have to buy. It could also be that he doesn't have the ability to buy it or something, or it's on the website and I just missed out on it. That's also possible. I think the easiest way to check that out is to go to the Crypto Law US. And why am I doing it this way? Because I think it's kind of funny to show you guys how I would be able to get this stuff as well. Because sometimes it's not as easy as I make it out to be, all right? Sometimes there's a lot of digging involved. And we got ourselves 3 updates just now. So let's see here, guys. It's not, you see, again, where do you find all this stuff now? Because you got to find people who bought this stuff. You guys seeing me? All right, let's just cover document number 1, though, and then we'll get into it. So here is, Dear Judge Torres, we write on behalf of defendants Brad Garlinghouse and Chris Larson together in response to the SEC's submission of the Second Circuit's non-presidential summary order in the Baron Helblitz, whatever. Okay, so what this one is about is the SEC very recently put up a new letter where they basically were informing the court of some new decisions made in the Second Circuit. If I get that correctly, I believe it's called Second Circuit. And now, obviously, that's positive for the SEC in the way that they draft it, in the way that they write it. And it's basically just a new decision which has to do with what Ripple can and cannot say as a basically a motion to dismiss argument. Now, what Ripple's arguing here is that the SEC's reliance on Baron is badly misplaced. Its latest filing illustrates just how unmoored its arguments in this litigation have become from the law. And again, we can kind of go into this deeper, but I don't think it's necessary. Let's just kind of put the baseline in here that Ripple doesn't think what the SEC is doing is justifiable. Once more, where they basically quoted a specific case here that just kind of went down. They're trying to use as a evidence for why Ripple's motion to dismiss is kind of incorrect. Let's put that basis in. So now we need to document the number 2, basically. But let's quickly see what Crypto Law wrote down first. They said, just add it to our document library. Letter of response from Brad Garlinghouse and Chris Larson to the SEC's citing supplemental authority in opposition to the motion to dismiss. This is a response to an SEC filing on October 7th, which Attorney Jeremy Hogan explained was ultimately not relevant to the Ripple case. I told you guys about the whole case. And at least in my opinion, it can be relevant because, well, it is something they want to use as an argument against the motion to dismiss, but it won't really determine anything too significantly. And they ended off saying, boiling it down a great deal in layman's terms, the lawyers for Brad Garlinghouse and Chris Larson essentially agree with Jeremy Hogan, stating, a court opinion was just issued which the SEC thinks is helpful for it as to the Garlinghouse and Larson motion to dismiss the lawsuit against them. So the SEC is just letting the court know it's not relevant to the case against Ripple. Peace out. So let's, I guess, just kind of, I don't know. He says, I got the name of the case wrong. It's Ripple v. SEC instead of SEC v. Ripple. How can we find document number 2 without, needing to pay for it, I guess? Why? You guys were asking me before, why don't you just pay for it, Dusty? Oh, don't think I wouldn't want to. All right, let's make one thing clear. Don't think I don't want to. It's just impossible. Okay, we cannot check this out. I'm trying my best to find the document somewhere where just some person... Okay, never mind. I've been trying my best. I have no idea how we can get this done. If any of you guys have an easier way to find these documents nowadays, let me know. Because I can see that they get posted, right? Don't get me wrong. It's pretty easy to see that. But how exactly to find some lawyer who's now posted it instead of James Phelan because he's gone for a little while, like he said, is a little bit more difficult to me. And maybe one of the easiest things to do is just head over to Twitter, maybe, or look at me say, Dutch guy. Okay, let's see. This is just all from the Ripple lawsuit. Could this be? Okay, so we got 2, yeah. Maybe he just didn't buy it then. Because we only got the 2 from October 12th, but this is number 1 and this is number 3. So I guess we could check out number 3 then. We're not going to see number 2. Then again, let's actually see what it was about. This is a reply to response to motion. This is a letter reply. Maybe it's the same thing. And this is just a start or something like that. Could also be. Letter reply, selected parties. Maybe this is just sent to those selected parties then, and this is the actual thing. Let's check it out. By the way, this just came out as well. Usually I do a live stream about it. I don't think we'll go live. Maybe I'll go live in just a second as well, but this is in a summary for all you guys afterwards, I guess. So, dear Judge Netburn, defendant's response to the SEC's request for a protective order as to defendant's 29.9 thousand request for admission is misleading in several respects. First, the fact that a case is complex, significant, or well publicized does not permit a party to burden its opponent with a crushing number of RFAs. That is abusive, unreasonable, and oppressive. They have a case to kind of put that in. Second, many of the RFAs are disputed, irrelevant, or otherwise objectionable, and therefore are unlikely to result in any useful admissions. And third, defendants recently served the SEC with expert reports that address the same issues as their 5th and 6th set of RFAs, rendering those RFAs cumulative and duplicative. For these reasons and those in the SEC's opening letter, which is docket number 367, the court should grant the SEC a protective order as to defendants' 30,000 RFAs. And their arguments are: 1, Rule 36, which Ripple uses, does not authorize the use of excessive and burdensome requests for admission, even in complex cases. Defendants' 4th, 5th, and 6th sets, which, again, guys, just see it as this. Let's say you have 6 sets of different sorts of questions. And again, let's just say it's 30,000 divided by 6. It's not literally like that, but let's just see it as different sets of questions, right? So the last 3 sets include many RFAs that are disputed, irrelevant, or otherwise objectionable. And then let's quickly see if they have any good arguments. Defendants' 5th and 6th set of RFAs are improper. Now the defendants have 2 experts proposing to address these same issues, and that is basically it. So what is the DSWC opinion on the matter already? It's a logical little thing. Again, guys, this is from the SEC side. It's pretty logical that they do not want to respond for 2 reasons. 1, it's a lot of work, so obviously you'd rather not, right? Obviously. But more importantly, anything that you admit like that in these admissions, the purpose of this is to get exactly where the SEC is coming from in suing Ripple and to kind of gouge what they know. So one of the things which Ripple, for example, states is that the SEC might have never read their contracts, so they cannot really reasonably claim that Ripple had a breach of contract or what I call it in the best way, sold investment contracts when they don't know what is really in the contract themselves. So Ripple's asking, for example, have you read them? But more importantly, they're, for example, asking, like was on the interrogatories, what part of the contract makes you think we are selling investment contracts? And that is, in my own opinion too, to kind of gouge the situation and reason why they've been sued and really what the grounds are. Because as we've stated before, it's pretty difficult to find out exactly what the case is built on and what exactly they're going after, because there's a couple of speculations, like XRP is being sold as a security, marketed as a security. It's only about the bigger partners. It's about every single secondary market and whatever as well. There's some questions about it, and I don't think there should be any question in a lawsuit of this proportion about what exactly the underlying threat is and what it is based upon. Like, for example, can the contracts even be proven that they're wrong or not? And again, in 30,000 questions, they're basically asking the SEC all this stuff. And I can understand that it's a lot and you don't want to. I can definitely get that. But I don't think they really have the best arguments. And even if they do, they're basically just pointing it towards that latter half, right? So the first couple of RFAs, I guess, would just pull through anyway. Yeah, because they're talking about 4, 5, and 6, and then 5 and 6. So I guess maybe 1, 2, 3. I saw Ripple say that I believe the number 6 was the most important. But then they're now saying that Ripple's also getting some experts in to already kind of ask questions about the 6, so they think it's duplicative. Guys, I cannot say who's going to win this one. All I can say is that I don't think it's too strange for the judge to still say, you know what, SEC, you're still going to have to answer all this stuff, because it's just kind of logical, you know? It's kind of logical, if you ask me, that they would have to kind of answer a lot of these questions that set a baseline. Same thing for the interrogatories that we were covering earlier. It's kind of the same thing, right? So yeah, I wouldn't be too amazed if they actually have to go through. You know what? I had some other stuff to talk about, but I guess we'll skip that for later. I'll just keep this a quick lawsuit update for everybody. Yeah, so 2 things, both not really big deals, to be honest with you. First one is Ripple stating that the SEC is wrong for asserting something, that this new case matters, basically. And the second one is the SEC still trying to not deliver on just some responses, basically. And both are not necessarily bullish or bearish for the case. It's just an update, you know, you guys understand. All right, guys, that was it for today's video. Hopefully you all enjoyed it. Make sure you check out the Bybit competition. And I think tomorrow I'll also make a tutorial for how to trade over on Bybit, as a lot of you guys have been requesting that. So stay tuned for that, guys. It's about to get really freaking interesting. And again, 133 people are in, but we need to get to at least like 200 or so. Make sure you sign up. A link is down below. 50,000 XP on the line. Adios, amigos.